If you have a company in liquidation, you don't want it to be in liquidation. Can you terminate the liquidation? Yes, you can. And there needs to be certain circumstances that exist for the High Court to reverse the liquidation and give the company back to its director. We see this in a couple of different scenarios. One is you received a statutory demand, you received liquidation proceedings, you did nothing on either occasion, then it got called into court, you didn't turn up, you were just busy working on the tools. Next minute you've got a liquidator in your office telling you the company's in liquidation. Suddenly, you're ready to take it seriously. Now, in that situation, if you can get creditors' consent to reinstate the company or terminate the liquidation, then that's possible. If you can get the money to pay the creditor, then you can terminate the liquidation. The other instance that we see is where maybe you still ignored the statutory demand liquidation proceedings, but because there was nothing you could do about it, you didn't have the money available and therefore you couldn't pay. But then, maybe a month later, 2 months later, 3 months later, there are some opportunities or some cash that become available. In that scenario, then you can go to creditors, make a proposal. That proposal could be to pay them now or pay them over time. But as long as they consent to the reinstatement of the company, the High Court will terminate the liquidation and reinstate the company. It's one of those things where if you have consent, almost anything is possible.